Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and today I will talk about the case of Union of India versus Manraj Enterprises, wherein the Honorable Supreme Court discussed the rule of adjustum generis in the field of statutory interpretation. Black's Law Dictionary 8th edition defines adjustum generis as a canon of construction that when a general word or phrase follows a list of specifics, the general word or phrase will be interpreted to include only items of the same types as those listed. Adjustum generis is not to be confused with nocere sociis. That means that the meaning of an unclear word or phrase should be determined by the words immediately surrounding it. Basically, nocere sociis has a general connotation and it provides that there exists a relationship between words or phrases that are associated to each other. Whereas adjustum generis is a rule wherein it is postulated that a general word or phrase may derive its meaning from the specific category or class of words that surround it. In order to understand more about adjustum generis, let us go through the pertinent observations by the court. Firstly, the court observed that the rule of adjustum generis guides us that where two or more words or phrases which are susceptible of analogous meaning are coupled together, they are to be understood to mean in their cognate sense and take color from each other, but only if there is a distinct genus or a category. Where this is lacking, that is, unless there is a category, the rule cannot apply. Secondly, the court noted that the rule of adjustum generis is applicable when particular words pertaining to a clause, category, or genus are followed by general words. In such a situation, the general words are construed as limited to things of same kind as those specified. Thirdly, the court warned that the rule of adjustum generis has to be applied with care and caution. It is not an inviolable rule of law, but it is only permissible inference in the absence of an indication to the contrary. Fourthly, the court noted that if a narrow construction happens on the basis of adjustum generis and such narrow construction or interpretation seems alien to the intention of the parliament, then a broader interpretation should be adopted in such cases by taking recourse to the principle of purposive construction to give effect to the intention of the parliament. And lastly, the court cited the case of quasi versus quasi, wherein a drawback of the rule of adjustum generis was explained. It was stated that if the legislative purpose of a statute is such that a statutory series should be read adjustum generis, so be it. The rule is helpful, but if it is not, the rule is more likely to defeat than to fulfill the purpose of the statute. The rule, like many other rules of statutory interpretation, is a useful servant, but a bad master. Thus, in conclusion, following important points emerge. A general word or phrase derives its meaning from the specific words or phrases that surround it. B. In order to attract adjustum generis, there must be a specific or distinct genus or category that should surround the general words or phrase, and without such distinctiveness, the rule shall not apply. C. The purpose of adjustum generis is to reconcile incompatibility between the specific and general words and construing a statute or a legal provision as a whole. D. The rule of adjustum generis must not be applied where the intention of the legislature is not to restrict the meaning of a general word or phrase. E. Like many other rules of statutory interpretation, adjustum generis is a useful servant but a bad master. Therefore, I hope that the meaning and the nature of adjustum generis as a tool of statutory interpretation is clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.